टेनेंट एविक्शन के मैटर में सुप्रीम कोर्ट की एक रूलिंग काफ़ी महत्वपूर्ण हो जाती है। यहाँ तक कि टेनेंट की तरफ से ये भी प्ली दिया गया था कि पिछले सूट में कॉम्प्रोमाइज़ हो गया था टेनेंट के बने रहने के लिए। मैटर इस तरीके से उठा कि लैंडलॉर्ड ही वॉज अपीलांट बिफोर द सुप्रीम कोर्ट. He approached the court for eviction of the tenant on the ground of default in the payment and for eviction, and for establishing an ultrasound machine for his two unemployed sons. Argument was advanced that the landlord was having other alternative accommodations. Supreme Court concluded supporting the trial court decision that it is a landlord to decide which accommodation is required for establishing such machines, and the status of the case duly proved that the location was very appropriate for setting up medical machines. Secondly, another argument was that his two unemployed sons were not technical expert and therefore could not run the ultrasound machines. So in this regard, the observation of the Supreme Court becomes very important, where the Supreme Court said that nowadays it is not necessary that for running or for establishing ultrasound machines, the person should be technical expert, but he can hire the expertise in such fields. So bona fide need was also established. The need for that specific location was also established, where it was more appropriate to set up medical machines rather than at any other accommodation available with the landlord. On the ground of earlier decree on the basis of the compromise between same landlord and tenant, the Supreme Court observed that that was around 20 years ago, and that compromise revealed that the appellant had allowed the tenant to continue in the premises, which was reconstructed by him. But that compromise deed nowhere is mentioned that the landlord will not initiate in future any proceeding for eviction. Substantial time had elapsed. Earlier suit was for establishing his brother, and now the present suit was for establishing his two unemployed sons. So purpose was also valid and genuine. Thus, the order of the appellate court as well as second appellate court, that is Ranchi High Court, was reversed by the Supreme Court, and the bona fide need was found proved, and the appeal of the appellant was allowed.